So this is about the VR/AR patent gold rush, turn your ideas into gold. And by gold rush, I mean literally that. There are tons and tons of patents being filed in this area. In the US alone, there are over 18,000 patent applications just on virtual reality. So it's a huge area, and a lot more are being filed. Of those 18,000 applications, nearly 20% were filed in the last year. And patent applications, as we'll discover, publish 18 months after they're filed. So what we're seeing is just the beginning of a huge rush to file and to patent. This is me. I'm Graeser. I've been doing this now actually for 21 years. Programming since I was 16. I was with the Human Genome Project for 4 years doing image processing. But I'm also former vice president of intellectual property at a company called Compugen. So I'm used to being on the other side of the table. How do you know what to patent? How do you know when to patent it? Is it even protectable? And is it worthwhile filing now or waiting? These are some of the questions we're going to talk about during this presentation. Oh, and please make sure the folks over there get it too, if you don't mind. Thanks. This is what happens when you hang out too long with lawyers. Nothing in this presentation or in any material provided, whether verbally or in writing, constitutes legal or patent advice. So why bother with patents? So I'm going to tell you a sad, sad story. It's about a little startup called Pixite. They produced the first native iOS photo app. So this is a while ago, back in 2009. Pixite had a great first mover advantage. They were literally first. They had no competitors. But the small company had no money. But they had lots of innovation. Now you'd think that this would be, a great story because they had all these innovative ideas and they kept on innovating to stay ahead of their competitors. But unfortunately, Pixite was smashed by a competitor called Lightricks, with little innovation but lots of money. They had a huge marketing budget. And they basically blew Pixite right out of the water. Because Pixite never filed for patents. See, Pixite had all these wonderful ideas and all this great software, but because they never filed for patents, Lightricks was literally able to copy all of their ideas. And Pixite could do nothing about it. The big question here to answer is the fact that you are not alone. Software and hardware can be created anywhere in the world. But ambitious companies can be stopped by patents, as Xiaomi was stopped by Ericsson. So Xiaomi is a handheld maker. They make cell phones. So does Ericsson. Xiaomi started in China, where they're based. They wanted to move to their next market, which was India. And they couldn't enter the Indian market because Ericsson had a ton of patents. And then Xiaomi realized the situation was even worse in Europe and the US. Without patents, Xiaomi was effectively blocked from those markets because they had nothing to trade with the other patent holders. So Xiaomi vowed revenge. The chairman said they would file 10,000 patent applications in 2 years. By the end of 2015, they'd filed nearly 5,000, most of which were actually not filed in China. They were filed in the US, Europe, Japan, and Korea. Of the top 5 patent filers in Europe last year, only one was a European country. 2 were Korean, 1 was Chinese, and 1 was American. So international competition is also heating up in the patent arena as companies file all over the world to try to maintain their advantage. So first we're going to talk about an introduction to patents, and then how to protect your VR/AR ideas and stop copycats, and then why patents don't have to be expensive. So here's why patents are a competitive advantage. All of these companies have something in common. They've all filed for patents in the VR and AR area. Now Survios, this is kind of their main thing. But Amazon has filed. Snap, used to be Snapchat, has also filed, possibly involving their glasses for AR. Google and Microsoft have all filed many patents and patent applications in the VR and AR areas. By the way, I will send the presentation after. So So, patents. Patents are the broadest protection for your idea. In order for an idea to be valuable, you have to share it. Unlike physical property that you can lock up. So you can lock your car or your house and only decide who you're going to share it with based on who has the key. But with ideas, if you don't share them, they have no value. On the other hand, if you share your ideas, someone can copy them and can steal them from you. Patents are the best defense against copycats. And the reason why is they protect the core of your idea, not just how you do it. So if you have a software or hardware idea, in VR or AR, for example, you can actually protect the concept, not just exactly how you plan to implement it. You can also block competitors from entering your market space. In other words, you can make your market space your own, so that only you can do business in that market niche. But that's only possible with patents. So what is patentable? Well, the top line is from a Supreme Court decision. Anything under the sun made by the hand of man or woman. It includes software, hardware, and high tech, but also proteins, drugs, mechanical devices. Basically, what is patentable is technology. And software and hardware are in what is known as a patentable category. They're in categories of technology that can be protected with a patent. So the patentability rules, first of all, your idea has to be in a patentable category, like software or hardware. It has to be novel, which simply means new. It also has to be inventive, which means it has to have the wow factor. Now that is a very hard thing to characterize. What is the wow factor? Basically, you need to do something beyond the standard in the field, beyond what someone of ordinary skill in your field, that is a regular worker in the field or a team of workers, would be able to do. It has been subject to tons of court cases. There is no bright line standard. But if you don't have this wow factor, your idea is not patentable. Finally, your idea has to be well described in a patent application in each country where you want patent protection. If you want patent protection in the US, you have to file in the US. If you want patent protection in China, you have to file in China, and so forth. Now, you don't have to file all at once. You can start with an application in one country. But if you don't continue to file in the other countries, companies or people in those other countries can copy your idea, and they can sell it in that country. So what is not patentable? Well, music, images, books, video, etc. Those are all protected by copyright. Now, to make it a little more confusing, computer code is protected by copyright, but not the computer idea, not the software idea. The software idea is protected with a patent. Copyright is a narrow right. It has to be a fairly direct copy. Names, logos, slogans, Coke, Coca-Cola, Coke the real thing. Those are all trademarks. And also what is not patentable is anything that you want to keep secret. If you have software, which is running off on a server somewhere, and from the client calls to the API, to the server there, you can't tell what's going on, then you might want to keep it as a trade secret. But if it is accessible to the user on a headset, on a phone, or some kind of device that's downloadable, then you would want to patent it, because anything a user can access can be reverse engineered. So you can get a patent in 4 simple steps. You do a search to see if you're first. You prepare your drawings and your text. That's fairly simple. I'll show you an example of a patent drawing. They're very easy to do. If you can whiteboard your idea, you can do a patent drawing. You file your application. Well, that's easy. And then after that, the examiner checks your patent application. That is where things bog down. You would think from this simple list that you would have your patent then, within a few days after filing. And indeed, you can you do your search, get your patent ready, file it very fast. And then it slows down with the examiner. It can take 1 to 5 years or more for the examination process. But this is actually a good thing, this backlog. Why? Because a patent application is like a startup. It represents potential. The earlier it is in the process, the less anyone knows actually what's going to come out of it. as long as your application is pending, which means you filed, so now you're patent pending, you can argue that you have the potential for very broad claims, for very broad protection. Once the examiner examines it, though, then you know exactly how much protection you're entitled to. So actually, this long period of time is very good for startups. It gives a startup a chance to get traction and get in the market and do a lot of sales. And in the meantime, you have that broad potential in your patent application. So here's an example of a patent drawing. This is actually from, I think it's actually one of Snap's patents. And they're dealing here with augmented reality. You can see we have users wearing augmented reality glasses, phones, connected to a Wi-Fi or to a central tower. The network always shown as a fluffy cloud. It's like a rule. And then we have here a server. So this is basically a client-server system. Now you don't need the fancy drawings. You don't need something that looks like a server or looks like a person. You could just have this all be boxes. So this basic system is an example of a patent drawing. And as you can see, the level of detail is not very extreme. So it's quite easy to do patent drawings. So before you get a patent, your application is property. As I'll mention later on, for each patent that you file for a startup, your valuation will increase by approximately $1 million. It's a rule of thumb that investors use. Your patent pending, mark your website and your app. There are some startups who actually use patent filings as psychological warfare. One company in particular, whenever they file for something, immediately states on their website, we are now filed, we have patent pending for XYZ. And the reason why I know this is because every time they do that, my clients' investors see that, and then they come running to my clients, and my clients come running to me saying, can they get that broad protection? So advertise it. Also, if you file first, you can block others from getting a patent. The way it works is it doesn't matter how long you're working on your idea. What matters is who files first. So if I'm working on my idea for 3 years, and you're working on your idea for only a month, but you file before me, you win. In the US in particular, prior use or prior working on an invention is not a defense against patent infringement. That is, against claims that you're trespassing on someone's patent. So you want to file fast or publish fast, and I'll describe why in a few slides. So when to file? Well, if you publish your idea, you can still file in the US within 1 year of publication. What is a publication? It could mean selling your app or your hardware. It could mean describing your idea in a public forum. This is a public forum. It could mean publishing it on a website or in TechCrunch or Silicon Alley or any of the different venues for public distribution of information. So once you've published, the clock starts ticking. You have only 1 year to file in the US, and you're blocked from filing outside the US. Now, as we'll describe in a bit, it's not necessarily bad to publish. If you're certain you only want protection in the US, you would benefit from publishing quickly. Why? Because once you publish, only you are entitled to that 1 year grace period. No one else is entitled to it. Once you publish, you have blocked others from filing for a patent. So you want to either publish fast or file fast. Now, why file fast? Well, once you have a design of your idea, you can file. You don't need to have built it. So that's a really great way to very quickly get protection, and it also gives you the right to file outside of the US. So if you're thinking of a big competitor in China or Europe or some other country, then you would want to file quickly and maintain your right to file outside the US as well. But feel free to stop if you have any questions. So now I'm going to talk about how to protect your VR AR ideas and stop those copycats. US patents in particular provide a competitive advantage. As I said, they increase the valuation of a startup by $1 million. This is also true for patent applications. Why? Because they represent potential. You don't necessarily need to have a patent for it to increase your startup's valuation. Investors like it because they like the potential that you can actually block your market niche, and what they don't want is to invest in you and then be like poor Pixite and have your ideas taken by a competitor, as Lightrix did to Pixite. US patents were also shown to increase sales by startups. Now, it's hard to know if this is correlation or causation, but when it comes to enterprise, there may actually be an element of causation. Why? Enterprise, big companies don't like lawsuits. They're afraid of risk. It's already risky enough for them to work with a startup. But if the startup doesn't have IP protection, hasn't filed for patents, then they're worried that their competitor could come along and then later on say, hey, you big company with deep pockets, you're infringing my patent, and you're not working with me, so I'm going to sue you. So they don't like that. Another point, it was found that US patents increase employment by startups. Now again, correlation or causation, hard to know, but because it increases a startup's valuation, it can make it easier to get investment, and it can also make it easier to gain traction because, again, of the fear of a big company of working with a startup that doesn't have patents because of the competitors. So why you should file for VR and AR patents? Well, here I'm saying protection and defense in the US market. Now, patents give you the right to stop others from trespassing on your ideas. So most people think, yes, I want to get a patent so I can go to court. But actually, a very big reason, especially in this space, which is heating up with everyone's patents, and which is also, by the way, proven to be very litigious, there's a lot of lawsuits flying around, is patents can also help you with defense. If a company sues you and you have a patent, you can countersue, or you can offer to give a license. Many patent lawsuits never actually go to court. They're settled by what is known as cross-licensing. In other words, I have patents, you have patents, let's share. And now we're best friends. And it's going to be us against the world. But if you don't have anything to share with, then you can't use that route to defend yourself against patent lawsuits. You can use it to get investments. You can also use it to work with a partner. A patent makes it much easier for you to license your technology. Maybe you want to license it to a much bigger company who would then go out and sell it, like the Intel Inside OEM idea. Patents make that much easier. It also can help you have a better exit. Big companies, if you decide to go the selling yourself route, big companies like to buy small companies that look like them. They're like a mini-me. And one of the things that big companies have are a lot of patents. So big companies like that. If you decide to IPO, patents and applications will also help you there. Facebook, before they went IPO, were told they didn't have enough patents. So they had to run around and buy a bunch of patents in order to be able to go IPO. Obviously, if you're filing from the beginning, that's less of an issue. Google, for example, filed for patents even before they were Google, even before they started their company. So by filing early and continuing to file, you can protect yourself. Patents also give you control. You can decide how others use your idea. For example, if you want to allow nonprofits to use your idea at low cost or no cost, you have the right to do that with a patent. You don't have to use your ideas with everyone the same way. It's your choice. You can also block others from patenting your idea. Again, if you file second, you lose. Snapchat almost lost one of their important patents. If you're on their Messenger app and you hold down the camera button, it turns into video, immediately toggles into video mode. They got a patent on that with a 19-day filing difference from their nearest competitor. Now, they were under the old US rules where it was first to invent. Under the new rules, which hold today, whoever was on the wrong side of that 19-day divide would lose. So you really do want to file quickly. You don't know when others are filing, but if you file, at least someone can't block you. You can also keep big companies from stealing your idea. Microsoft is somewhat notorious for this. Microsoft keeps on being sued. In a number of cases, they simply bought the company suing them. It was just easier. One example was XML, turning a Word document into XML. You know, they have that feature now in Microsoft. Well, a startup came up with that idea, and they got a patent. And then Microsoft met with them, and then amazingly, shortly thereafter, was able also to turn their Word document into XML. It was just a coincidence, said Microsoft. Nothing to do with meeting you guys and talking about your idea. So the startup went to court, won, got a huge judgment. I think it was around $40 million, $50 million, something like that, which for the time was quite large. This was a number of years ago. And Microsoft had to pay up. They didn't have a choice. You can also think about the case of Research in Motion, BlackBerry. They were sued by a holder of a whole bunch of patents who basically just wanted to license or sell them for $40 million, which wasn't a whole lot of money, compared to the eventual damages that RIM had to pay of over $800 million. So even small startups can defend themselves against big companies if you have patents. However, you also don't want to get bitten by the IP or intellectual property of others. So what you don't know can hurt you. Oculus was sued for patent infringement. Not knowing about a patent isn't a defense. I mean, Oculus said, look, we just said no, but that's not a defense. If you're trespassing on someone's patent, you're trespassing on someone's patent. Startups could even be blocked from selling their technology. There are a number of lawsuits in the VR space in particular, but also in the AR space, which have been going on. And the reason why is that patents have been developed for quite a number of years. And so some companies are already ready to go out and defend themselves. So you want to be certain you're not going to be blocked. You need to protect yourself, but you also have to know what are the rights of others. Companies are filing for VR and AR patents fast. I mentioned how quickly the patent applications are being filed for. We're expecting about 1,000 patents in the VR AR space to be granted just in the US in 2017. And next year it could even double. And the reason why, the rate of patent filing and the rate of patent grant is going like this in VR and AR. There's a huge backlog that's coming forward now. So Sony, Microsoft, and Samsung each have hundreds of patents in this area. Apple and Oculus through Facebook are catching up. Everyone is filing because they're afraid if they don't file, someone else is going to file. And startups are actually getting caught up in this as well. For example, the startup NextVR has 24 patents and applications. They published 14 in 2016 alone. This is a small startup. If they have 24 and they already published 14 only last year, you can imagine how many they're going to publish this year. By NextVR, those are the guys who do the sporting events, basketball. Yes?
Do you know what type of patents they apply for?
Well, for the areas they're applying for, I checked a number of them. A lot of them are for software, which kind of makes sense. When they're filing in the US, they'd be filing what is known as a US utility application. That's what's actually examined. That's what publishes. I didn't check to see if they had filed provisionals first, but a number of startups in this space have, and I'll get into what a provisional is. If you have hardware, you can also file a design patent. But a design patent only protects the way things look. That's why it's so hard to protect software with the design patent, because it kind of changes all the time. But if you have like a headset or some hardware device, you can file for a design patent to protect the way it looks. But it doesn't protect the inner function. So if you have like particular inner functions that are important, you'd have to also file for a regular utility patent application. This, as I said, can also be a defense against big co-patents. If you have your patents and they have patents, you can at least come to a deal. Or alternatively, they may simply buy you. It's often cheaper to buy you than it is to get entangled with you in a lawsuit. Now, if you're worried about how a startup could actually afford this, first of all, in the US, there are quite a few litigators who do patent lawsuits and will only ask for money if they win. So in those contingency basis, you have to put a bit of money up front for the filing fees and for some experts and all that, but it's not so much money. I actually know one law firm that does this. Over 40% of the work they do is on a contingency fee basis, and they say they actually make most of their money that way. So they're happy to do it, yes.
Are there any law firms that are in the VR, AR space that are regarded as the blue chip, like 3 or 4, just they have the most market share, if you had capital, those are the ones you would hire?
Well, not in the litigation space, because I don't think there's been enough litigation yet.
I meant more in the filing.
In the filing space. I'd actually have to check and see, because what I have found, I mean, of course, we do the work, but we're like more of a boutique firm. There are also some very big firms that do the work. The issue there is it's usually certain specific people doing it. And I can take a look. I have some notes on like who are good people, but the issue then if they switch firms, it's not the firm, it's the person.
Wouldn't a lot of those big corporations have in-house teams as well?
Sure. No, you're right. So for example, Google, Amazon, those guys, they all have like an in-house team. And a lot of what happens with the in-house teams is they'll do the initial work, or they'll maybe come up with the core of the idea, the core application, and then they will give it out to someone else to file. As a startup, you don't necessarily always want to work with the biggest firm because you can kind of get lost in the shuffle sometimes. Sometimes the more boutique firms can be better. But again, there it all boils down to individuals, you know, who actually has the knowledge in this area. Copyright is also important. So if you have an AR or VR app or software that uses music or images of others, it could be liable. So there was a Pirates of the Caribbean AR app. It was made by a professor. It was a social commentary. What it does is if you hold your phone up, if you have the app running and you hold your phone up to a Pirates of the Caribbean poster showing Captain Barbarossa, one of the characters, the app will change the face of Captain Barbarossa to that of Lloyd Blankfein, who is the CEO of Goldman Sachs. He was making a comment on who's the bigger pirate. That might be fair use. Fair use in copyright is basically when you're allowed to do certain things, for example, for social commentary. But you need to be careful not just to randomly use images, music, or other copyrightable things that belong to other people. Instead, you have to consider what it is you're doing with them first. And of course, you can't forget trademarks. You can't use brand names or logos without permission. There have been some cases of this where folks were, you know, they weren't necessarily using it to try to pretend that they were working with the company or they're doing something on behalf of the company. Is simply an example, but it caused some problems. So the best defense is to find out your rights first. In other words, talk to someone who's experienced in IP matters, who can help guide you through this particular minefield. So what and when to patent? Well, what do you want to patent? You want to patent the heart of your business. This is the part of the business that if someone were to copy it, you couldn't live without. If someone were to steal this part of your business, you would actually lose your business. So you definitely want to protect this with a patent. But you also want to protect anything that the user experiences. Now, the user doesn't really care about your awesome tech. What they care about is the solution you're bringing to them. And they experience the solution in a certain way, you know, through the UX, through the user experience. So anything that a user can experience, you want to make certain that you protect with your patent, because you don't want your competitors to get a hold of that. With Pixite and Lightrix, for example, with the manipulation of the photos, Lightrix literally copied this. I mean, pretty much one-to-one copy of what was going on. And they did that deliberately because they knew it worked well, because Pixite had opened up the market for them and had shown what worked and what didn't. So you want to block that kind of behavior on the part of your competitors. So instead of them copying what you did and then, you know, using their bigger marketing budget to blow you out of the water, you want to be able to protect your idea so users come to you and not to your competitor. You don't want to wait to files, because someone else could file first and they could block you. Remember that 19-day difference. You either want to file fast or you want to publish fast. You don't want to wait and let someone else get the jump on you. You also want to develop a protection strategy. So US is best for software patents, but it is possible to protect your software and hardware ideas in other countries. Patents do provide the strongest protection. They're much stronger than copyright or trademark in protecting the core of your idea. And of course, you also want to talk to an expert. I'll briefly touch on why patents don't have to be expensive. So why are patents expensive? Imagine that you could only get clothing by going to a tailor and having a tailor-made suit. That is the way patents are today. And for that reason, they are extremely expensive. Each patent is hand-done just for you. We actually work with a different system where we use a lot of automation, and we use a lot of processing to make things go faster. We also, by the way, charge fixed prices. Most patent attorneys charge by the hour, so they have no reason to be efficient. One way to save money and get your foot in the door and get something filed quickly is by filing a provisional application. This is only available in the US, and it only lasts for 1 year. It's not examined, and there are many fewer rules. So provisional applications allow you to quickly describe your idea, get it filed, get patent pending. Once you file your provisional, you're patent pending just like for a full or utility patent application. But because it has fewer rules, it's faster and it's also much less expensive. If you are not certain what it is you want to protect, at the end of the year, you can make changes, you can add ideas. So for this reason, the provisional also gives you flexibility. At the end of that year, you can file in the US, but you can also file in China or Europe or anywhere else you want to file. Also, if it turns out that you're not ready to file now, you decide to publish quickly. The end of that 1 year comes up. You can still file a provisional application inexpensively, and now you're effectively getting 2 years to work on your ideas. Even better, if you publish now quickly, within 1 year, you file your provisional, but you include new ideas that weren't published, you can file those new ideas at the end now of the 2nd year in countries outside the US. Of course, the published ideas you can only protect in the US, but the new ideas you can protect all over the world. So you can actually get a great deal of protection and extend the process to when you have money over 2 years. So provisional application is a huge advantage. So can you do this yourself? Well, yes, you can, but you need to know the following. Idea protection can be complicated, and you need a strategy. You also need to be confident that you're making the right choice. The reason for this is in patents, not making a decision is the same as making a decision. If you publish your idea, but you go beyond that 1st year before you file your provisional application, well, then you've lost the ability to protect that idea even in the US. So you want to know when you decide that you are making the right choice. And for that reason, I do urge you to speak to a patent expert before you decide to go forward. And certainly, waiting is also bad. Not filing can be bad because then someone else can file before you. And of course, not publishing or filing, you could be beaten to the punch. Well, that's it. Does anyone have any questions? Yes.
When filing a patent, let's say you have a novel and inventive idea, but worse comes to worse, and after being reviewed, a main part or some critical part is deemed as not patentable or already owned by another company. In such a position, especially if you've already created a company, if you don't have anything else novel or enough to cross-license, say, with this company that also owns.
Yeah, the other one, yeah.
What can you do in terms of, by not having multiple inventive ideas, are you just not in? Help me out.
Okay. So that actually question does come up, especially with that 18-month black hole for publishing patent applications. Sometimes what happens with my clients is they think they're first, and they even do a search, and it looks like they're first. Then they file their first patent application, and then another company's patent application that was filed earlier publishes. So that is actually, unfortunately, not uncommon. For that reason, I always, first of all, stress filing as many ideas as possible, but also going into detail. For example, suppose you have a technology, but you also have a business application for your technology. In the US, the business application is also patentable, even if it turns out someone else had already filed for the technology. So you want to include as many different ideas as possible so that you also have a fallback position. Another issue in that would be filing a very detailed patent application. Even with things you haven't built yet, you only have like the most basic design. And again, it's because you don't know what someone else has filed. You could have like a main idea and a few other, maybe ideas you feel are interesting but you think would be less crucial. But if that's all you can get protection for, that can still help you with negotiation, because it could be for the other side, those ideas are the crucial ones. Also, if you file a patent application, it's good to think about what your competitors are up to. And the reason you want to do that is because you can block your competitors and then later reach a deal with them. So if you have a competitor and you have some idea of where you think they'll end up going, if you file for a patent application to block them, then that gives you something to trade with them, or to do a deal with them, for that matter. So patents actually can have multiple business uses. They're not just for protecting one exact core idea, but they're also for protecting the periphery of ideas, and also to allow you to defend yourself, if it turns out someone else filed. Answer your question?
Yeah.
Okay. Oh, yes?
Can you talk more about what your company actually does and how that compares to like a traditional patent?
Sure. I did not plant him in the audience, by the way, but thanks for asking the question. So KISS patent is different from traditional patent firms because we put the power of patents in the hands of startups because we have fixed prices and we have much lower prices. We also have a very specific process that we use. That process takes less of your time, which is very important because we want to be efficient because it's fixed price. It doesn't help us if we end up going through an inefficient process with you, but it also doesn't help you because more of your time then is wasted. In terms of our prices, for example, our basic provisional application package to get your provisional application filed, you do the drawings, we do the rest, $2,500. And it's a fixed price. We are also working on automating the patent and trademark process. Right now we use the automation behind the scenes just to help us be more efficient so we can lower our prices. But we will be releasing our automated trademark application for filing trademarks later on this year. And at the end of the year, at the beginning of next year, we'll actually be releasing our patent automation. So eventually we want to do as much work as possible in such an efficient way that we can continue to lower our prices. That's our goal. And thereby expand the possibility of getting patents to as many startups as possible, not just to the big companies. Yes?
Can you elaborate or clarify on the provisional filing after the 1 year? How do you get 2 years out of that?
Okay, so that was if you know you want to file mainly in the US, or you don't have any money right now, let's say, or you're not sure what your idea is. So then what I suggested is you publish your idea. That gives you the first 1 year clock in the US, but only for the US. At the end of that 1 year, you then file your provisional application. Now, you're patent pending in the US. All of the ideas that were published before are patent pending in the US. That's good. But if you have any new ideas, you could actually file those internationally.
So that's doing the publication before the provisional filing.
That's correct.
The other way around.
That's right. If you, of course, if you want to file outside the US, you have to file before you publish. Hang on 1 second. I'm just going to, can you shoot this? So I don't know if you got on the sign-up sheet. I'm sending out a copy of the presentation and the video, but also you'll get a chance to have a free conversation with me just because we're trying to keep anything private or secret out of the public forum. Yes, you were first, I think.
In terms of presenting your idea outside the US, so there is only one way to go if you want to protect your idea around the world from the very beginning.
Well, then you'd have to file before you publish. If you want to protect your idea outside the US, you have to file before you publish the idea you want to protect outside the US.
Only a patent or provisional?
Provisional, if you file the provisional, you're patent pending and you can publish your idea, and still within 1 year file outside the US.
Within that 1 year, can other people outside the US take your idea or patent your idea outside of the US, within that one window with provisional, you cannot protect your idea?
No, actually, that's a very interesting question. But once you file for the provisional application, you have a date. As long as you file in other countries at the end of the year, let's say in the US, you get that date in the US, right? If you then continue and file in China as well, you have that date in China. If someone filed after you filed your provisional in China, your date is earlier because everything in your provisional application gets that first date. So as when they're comparing two patent applications, they look to see which ideas were filed with the earlier date. That's why it's really important to put in as much detail as possible, because you want everything to be traced back to that first date. You want everything in that provisional so you can say, well, I deserve this earlier date. I'm first. So again, that's why it is good to file quickly. Now, if you publish quickly, you've effectively blocked others from filing for a patent as well. All right, so that's why publishing quickly is also good. A publication in the US counts all over the world as a publication. Same way as a publication in China counts all over the world as well, by the way. Everything that people publish in China in Chinese is also used by the examiner to see if your idea is new. All right, if it was published in China, let's say, before you filed. So it ends up being important to understand what's going internationally, but also it's very difficult to do a search and know exactly what's first because of that 18-month black hole for patent applications. Because the date that counts is the earliest date, not the date the patent publishes, the date it was filed. I hope that's more clear. It gets a little bit tricky. Usually I end up diagramming this on the whiteboard with some examples. But the simple bottom line, again, is file fast or publish fast. Both of those activities will protect you, just in different ways, like I said. Any more questions? Yes? I'll go over here. So you're going to speak with someone privately, but before you patent your idea. Okay. Right, so the question was, if I'm going to go speak to an investor, but I haven't yet filed for my patent application, what do I do? Well, first of all, a reputable investor should not steal your idea. One point is that, of course, any conversation you have, you should just state, this will be private, state that in the emails. Mark anything you send to them as confidential. Normally, VCs won't sign an NDA, but at least if you mark it as private and confidential, it's clear it's not a public forum. If you are going to also talk to an investor, if it's a private meeting, that's fine. But if, for example, you're in a public forum like a pitch competition or something, that is a publication. That is not a private forum. Private forum is you're sitting with someone in their office and you're speaking privately. And then that's not a publication. So, but I understand you also need to speak with the investors before going forward. Quite a few of my clients have done that. They spoke to investors first, they got feedback, they spoke privately to various individuals, and only then they filed for their provisional. As long as it's kept private, not a publication, then you can still file internationally. Oh, yes?
In Europe and Asia, do they tend to file in their local languages or English? And if you were trying to do research, is there any way to reliably do that research without having to hire someone that knows the local language?
Actually, there is. So the question is, if you're looking for international publications, let's say patents or patent applications or anything for that matter, Google actually has a really nice patent search. They have a patent search that also includes Chinese, Japanese, Korean, German patents and patent applications. They have a pretty good automatic translation system. So if you put in the keywords, it's like a regular Google search. It's pretty decent. Sometimes the translations can get a little odd, so it's hard to know that you exactly found everything. Another way, I would recommend actually starting with that. Another way to do it is to have a professional do a search, because then what they do is they actually search by class. So patents are divided into a bunch of different classes, and the reason for this is not so long ago, actually, people used to search for patents by going through boxes of index cards. And they had like titles and patent numbers and abstracts. And so you had to just look at the class. You couldn't do a keyword search. So you would know that if I'm in this class, it's VR and AR software, and that class is VR and AR hardware, for example. So you can also have a professional searcher do a search by class as well. The advantage there is there's a little bit less of a language barrier, but it is very difficult to actually know if you've really found everything. The Google patent search tool, though, is quite good, and their translation service is quite good. So I would actually start there just to see what's out there. Also, the advantage of using the one that includes, for example, Chinese and Korean patents is I found there are quite a few patents and patent applications in China and Korea which are not necessarily filed in other countries. So you also want to look for that, especially in this space. Any other questions? Well, that's it. Thank you so much for coming. Please make sure you sign up on the sign-up sheet, and we will be in touch to answer more of your questions in private as well. And I'll send you the presentation. Thanks again.